Move that the House take note of miscellaneous business.
I so move.
Dr. Russel Norman.
Thank you, Mr. Speaker. Mr. Speaker, I stand today because, to paraphrase the words of Hamlet, something is rotten in the overseas banks in our country. We have now had some very serious cases of tax avoidance in our country. Two of the largest banks in our country have been convicted of massive tax avoidance on a scale that is seldom seen in our country. These are giant tax avoidance cases which the High Court of New Zealand has ruled on. The most recent case involves no less than the government's banker, Westpac. Westpac now owes, according to the High Court of New Zealand, nearly $1 billion in taxes and interest payments to the people of our country. That is, they have been found that they had tax avoidance of over $500 million, and when you take into account interest payments on top of that, they owe nearly $1 billion. In the words of Justice Harrison, who was the High Court judge in this case, he said, "I have rejected Westpac's primary arguments on all contested issues." Judge Harrison ruled that the 4 transactions in dispute were created solely for the purpose of tax avoidance. Mr. Speaker, it is extraordinary that the government's banker has just been convicted by the High Court of our country of putting together a series of transactions that were created, according to Judge Harrison, solely for the purpose of tax avoidance. Westpac had got to decide effectively in the judgment, if you read the judgment, Westpac got to decide what rate of tax they would pay in New Zealand, which, when you look at it from the point of view of the ordinary taxpayer who thinks that what you have to do is follow the rules and pay your tax, because we all know that paying tax is the price we pay to live in a civilised society, and all businesses in New Zealand know that paying tax is what you do because you are a good corporate citizen. It is extraordinary that Westpac got to decide what rate of tax it would pay. According to the Justice, not only were these arrangements unlawful, but the 4 transactions tested in the case were, quote, tax avoidance arrangements entered into for the purpose of avoiding tax. Anyone who's read this case will be amazed to the extent to which Westpac went to in order to have these series of structured finance arrangements, very, very complicated structured finance arrangements, in order to, in Justice Harrison's words, simply avoid paying tax. That was the only purpose of those arrangements. It is, I think, also quite sad that one of the people involved, in fact was one of the key advisors to Westpac in this case, was no less than John Shewan, who is now chairman of PricewaterhouseCoopers, one of our most important accounting and advisory firms. John Shewan, according to the judgment in the case, advised Westpac to make tax payments as low as 6%. Most taxpayers will be surprised by such advice, as low as 6% but no lower. This is in the context where the company tax rate in our country is 30%. They were being advised by one of the most senior tax lawyers in our country to have a tax rate of 6% but no lower. Justice Harrison wrote in his judgment, "The bank, that is Westpac, was anxious not to reduce its effective tax rate unduly because of its reputational effect. It wanted to appear as a good corporate citizen paying a responsible level of tax. For that reason, Westpac's Chief Executive Officer imposed a minimum effective tax rate for the Westpac Group of 25% in 1997. All these transactions took that factor into account. However, management progressively allowed the effective tax rate to fall first to around 20% in May 2000 and then into the high teens." Here we have the government's banker organising its tax affairs in order to reduce its corporate tax rate to under 20%. It is an extraordinary turn of events. And what is even more extraordinary is that one of their key advisors is now on the government's tax working group, John Shewan from PricewaterhouseCoopers.
Point of order, Craig Foss.
I apologise to the member for interrupting. Can I just ask Mr. Speaker via you an assurance that the matters the members are addressing are not before a court, not subject to appeal before the court, because there are very serious matters here, Mr. Speaker, and I apologise for interrupting, but I'm just concerned that it's strained very, very close, particularly given rulings around sub judice matters that came before the House recently, and I just would be comforted, or perhaps suggest that about comfort to the House that that assurance is given by the member raising these issues.
I was listening actually to the member speaking very carefully because it is obviously a sensitive matter. But I think we heard from the Minister that an appeal hasn't yet been lodged. I think the member speaking has been quite careful to, he's quoted from the judgment as I heard him and referred to the matters contained there. He hasn't made any, I've not heard any outlandish allegations being made that could perhaps be considered to be irresponsible. I think the member's been handling what is to him a serious matter in a pretty responsible sort of a way, and as I understand it, the matter is not at this moment sub judice. Dr. Russel Norman.
Thank you, Mr. Speaker.
The member has 32 seconds. We stop the clock.
Well, thank you, Mr. Speaker. I think that we have to say to the taxpayers of New Zealand, it is unacceptable when the government's banker has been convicted in the High Court of tax avoidance, illegal tax avoidance, to the tune of over $500 million. And what would ordinary taxpayers say to that situation? I call on Westpac and all those who are involved in this. It's time to clean up your act. It's time to do the right thing by the taxpayers of New Zealand. It's time to do the right thing by the taxpayers of New Zealand because they expect you to be good corporate citizens, especially in your role as the government's banker.